Question is, shall the bill pass finally? On that question, the Speaker recognizes the gentleman from Delaware County, Mr. Vitali.
Thank you, Mr. Speaker. First, I'd like to salute the gentleman from Lackawanna County for his strong advocacy of protecting children, protecting the murder of children. It's an incredibly heinous act, and I think anyone who commits such a heinous act should go to jail for a long, long time. So I salute the gentleman for that, and my heart goes out to the mother of Zachary. My mother lost a son, and I understand what pain is involved. But regretfully, I have to stand in opposition to this bill. There is an adage we learned in law school, good facts make bad law, and I think that might be the case here. I've had a little bit of a chance to investigate this, and I just wanted to, if I have any of the facts wrong, please let me know. By chatting with Assistant District Attorney Tallarico and the very fine maker of the bill, I understand the facts, and in talking with staff, I believe that the heinous person who did this heinous murder, in fact, received a sentence of 15 to 40 years. I believe, if I'm wrong, please correct me, 15 to 40 years was the sentence there. So I don't think the mandatory minimum this law would really perhaps not apply in that situation. The problem here is this. Every factual scenario is different. And what we're dealing with here is third-degree murder. And essentially what third-degree murder is an unintentional criminal homicide. And facts vary depending on the case. And I really appreciate Assistant District Attorney Tallarico explaining to me that 90% of the cases of unintentional homicide with regard to someone under the age of 13, I'll use 90% loosely, it could, is the shaken baby problem. The problem where you have a parent, perhaps a mother, who in an inexcusable and outrageous way shakes her child, and that results in death. Now, there's all sorts of fact scenarios from the very heinous to the tragic. But there are, in fact, scenarios where perhaps 13 years in jail is not the right sentence. Maybe 12 years, maybe 10 years, maybe 8 years, maybe 15 years, maybe whatever. You have to look at the individual facts. What, for example, if you had a mother who had an exemplary life and raised good kids, and maybe her house was foreclosed the previous week, maybe she caught her husband in an adulterous affair, maybe she was lost her job, extreme stress, but otherwise an exemplary person. I'm not going to say that would ever excuse such a heinous act. But you have to compare that to a vicious serial killer of children. And you need a judge who can look into the individual facts of each case and do justice and determine whether this is a crime that requires 6 years or this is a crime that requires 20 years. The problem with mandatory minimums generally, and this bill in particular, is it would tie the hands of good judges who want to do justice. Yes, there are certain judges who don't sentence stiffly enough. There are a certain group out there. But because of those judges, we should not tie the overwhelming majority of judges who really want to do the right thing based on the facts and circumstances of each case. We don't want to tie their hands and force them to impose a 13-year sentence when maybe an 11-year sentence is enough or a 9-year sentence is enough. We need to give judges the ability to look into the facts and circumstances of each individual case. Now, the prior record, the sentencing guidelines call for a case of an unintentional killing, which is what we're talking about here, of 6 to 20 years. Mr. Speaker, I salute the maker of the bill. My heart goes out to the mother of the child, but we have a duty here to look dispassionately at this and think about the courts throughout the Commonwealth, and we cannot impede the ability of the courts throughout this Commonwealth to do justice to all the individual fact scenarios that may come before them. And I think if we pass this, that's what we'll be doing. Thank you very much.
Question is, shall the bill pass finally? On that question, the Speaker recognizes the gentleman, Mr. Murphy, for the second time.
Thank you very much, Mr. Speaker. Just to briefly address some of the concerns that were brought from the gentleman from Delaware County, we're not here to be defenders of the defenseless. We're here to protect the defenseless. Right? Someone who would commit such a heinous crime against a child under the age of 13, and in this particular case that I was dealing with on a local level of a 14-month-old, I would contend deserves whatever they would get. The possibility and the concern that was posed by the gentleman that someone could, in this particular instance, and for this particular murder, the perpetrator did receive 15 to 40 years, which I would contend to be light. But that was the punishment. But for someone who commits a sexual assault of a child and to have that mandatory minimum be set at 10 years and under aggravated circumstances where there's serious bodily injury for that minimum to be 25 years, I would contend it's very difficult for any assistant DA or for any DA here in the Commonwealth of Pennsylvania or any Commonwealth or any county throughout the United States to try to explain to that bereaved mother that someone who still has their child and the person that committed the crime against their child, that sexual assault, could spend life in prison, but yet your child's life can be taken and that perpetrator, upon conviction, can receive as little as 6 years. It's not right. House Bill 601 addresses that, and I think at the very least, with the way this bill has been vetted out on both sides of the aisle and in the Judiciary Committee, and I'll repeat once more that it passed unanimously out of the Judiciary Committee, that most members of this General Assembly consider heinous crimes such as this of such a serious nature that we should impose minimum mandatory standards in sentencing. Thank you very much, Mr. Speaker.